Hi, you guys. I'm talking tonight about probate. That's been a request from a number of people. And I've been talking before about this idea of trying to avoid probate by titling things to pass without going through a probate process. And I want to just reiterate that really quick. So in a lot of states, you can pass real property via deeds that are like pay on death deeds. We call them enhanced life estate deeds in Florida. But there are other states that also have these deeds that would pay out, not pay out, but transfer on your death to your named remaindermen. So these deeds are very effective. Also, IRAs can be passed with beneficiary designations, pay on death accounts, so bank accounts, savings accounts, CDs, all these things can pass on death if you have titled them to pass on death upon your death. So the only types of assets that really would not pass on death are assets that are only in your name when you die. Those assets would have to go through a probate process. A lot of people use revocable trust instruments to pass things on death using a trust to give instructions of what would happen, like if you became incapacitated or if you died. And sometimes the trust can even continue on after death to provide what I like to call a legacy trust. So we can talk about that another time. But probate is the place where assets go when they're in the name of someone who has died. And so, there's a couple ways that the court system can deal with assets that are titled in the name of someone who died. And one is to review a will. So an original will would need to be deposited with the court. The court would review the will, make sure it's the original, that it was executed with all the formalities that are required by your state's statutes, and then they would admit the will to basically be administered. And that's what the probate process is. Now, what happens in a probate is that first the judge admits the will, and then a notice would be sent, and depending on your state's rules, it's usually published in a newspaper for a set period of time, where creditors can make claims against the assets of the estate. Usually there's a priority list of creditors. Funeral expenses, medical expenses, those things might be higher priority than, say, what would go to someone who's an unsecured creditor. And so that process happens. The personal representative is appointed. We call it a personal representative. It may be called an executor or an executrix in your state. That person is the one who's charged with filing everything with the court, marshaling all the assets, figuring out who the creditors are, paying the creditors if there are sufficient assets to pay them, and then making distributions to the beneficiaries. That, in a nutshell, is the probate process. And, it can take a bit of time. In Florida, it's going to take probably about a year, depending on where you live in the state. Sometimes it takes longer if there are disputes over creditors' claims, or disputes over, was this the right will, or was there another will that came after it? There's all kinds of ways that process can be slowed down. But for the most part, that process will take 9 months to a year, generally. All right, so that's probate. Hope all is well.